To build a functional legal system, you need precise definitions. Without a rigorous architectural foundation, the laws designed to protect society cannot be effectively enforced. In Singapore, animal law rests on a bipartite structure. On one side, the Control of Dogs Act manages public safety. On the other, the primary welfare legislation, the Animals and Birds Act, or ABA. But look closely at its foundation. Its jurisdiction covers any beast, bird, fish, reptile, or insect, applying the exact same legal standard to a dog as to an insect, making no distinction for cognitive capacity. Its primary protection, Section 42(1)(e), prohibits unnecessary pain or suffering. This creates a severe structural defect. The ABA completely lacks statutory recognition of an animal's capacity for subjective experience. Legally speaking, suffering becomes a highly ambiguous term if the statute doesn't formally acknowledge that the subject has the psychological capacity to experience it. This statutory silence creates a void that severely handicaps law enforcement. Without a defined parameter for mental states, authorities lack an objective mechanism to prosecute cases of non-physical abuse. This data funnel visualizes the operational consequences. In 2024 alone, the AVS managed 961 reported cases, representing over 2,000 known animal cruelty victims. Yet, historically, only a tiny fraction of these reports, roughly 12.4%, convert into successful prosecutions. The bottleneck occurs because investigators struggle to establish a legally actionable foundation for psychological harm under the current undefined statutes. When a case involves somatic pathology, visible physical injuries, it moves smoothly through the legal process. But cases requiring behavioral inference to prove psychological trauma hit a massive barrier. When the statute fails to define sentience, behavioral evidence becomes subject to unpredictable prosecutorial discretion and steep evidentiary hurdles. The Ministry of National Development has confirmed a comprehensive review of the ABA for 2026, presenting a high-leverage opportunity to clear this bottleneck. Relying on variable legal interpretation creates systemic inconsistency. A precise legislative amendment is now a strict operational necessity for consistent enforcement. We are currently operating in a gap between de facto and de jure recognition. While the written law remains silent on animal sentience, Singapore's common law has already evolved. The turning point occurred in 2016 with the High Court case of Public Prosecutor versus Ling Chung-E Roy, commonly known as the Hugo case. Hugo, a pet dog, was subjected to prolonged spatial confinement in a heavily restricted cage, notably without showing any measurable signs of physical illness or injury. The judge delivered a credible holding that effectively decoupled the legal assessment of an animal's welfare from standard physical health indicators. The court stated that Hugo must have suffered in the condition it was kept, establishing an objective reasonableness test based purely on behavioral inference. This trajectory culminated recently in the 2025 Lin Penglai Berry case, where the court explicitly characterized animals as sentient creatures. The judiciary is actively prosecuting cases based on an implicit assumption of sentience. As a result, the primary protective statute is currently lagging behind the very jurisprudence it is meant to govern. This matrix illustrates how other leading jurisdictions have legally codified sentience, mapping the level of legal protection against the complexity of implementation. At the highest level of obligation, we see the treaty-level model. Article 13 of the European Union's Lisbon Treaty places a mandatory requirement on all member states to regard animals as sentient beings. And then there is the constitutional model. In 2002, Germany amended Article 20A of its basic law to include animal protection, providing the ultimate safeguard against political regression. However, constitutional changes require massive parliamentary supermajorities and extended timelines to execute. Alternatively, jurisdictions can draft dedicated sentience legislation. The UK's Animal Welfare Act of 2022 explicitly mandates that government ministers have due regard to animal welfare in policymaking. Another path involves modifying the civil code. In 2015, France reclassified animals, moving them from the category of movable property to living beings gifted with sentience. When we plot these four models onto our matrix, a clear pattern emerges. Standalone acts and constitutional amendments offer robust protection, but they score extremely high on implementation complexity. For Singapore's 2026 review, drafting entirely new standalone legislation would be a slow, cumbersome process. Instead, applying surgical amendments to the existing Animals and Birds Act offers the most direct and politically viable path. We achieve this through a redlining strategy, inserting precise textual updates into the current act. We start with Section 2, defining an animal as a sentient being capable of experiencing positive and negative states. Codifying the capacity for both pain and comfort immediately provides a firm statutory basis for evaluating subjective well-being. Next, Section 41C, which covers the duty of care. We shift the standard from passive ownership to positive welfare mandates by adding the requirement to have regard to the sentience of the animal and its capacity for physical and psychological suffering. Finally, in Section 42, regarding cruelty, the vague phrase unnecessary suffering is expanded to explicitly list psychological harm as an independent punishable category. The immediate legal mechanic of these text changes is straightforward. They lower the barrier for evidentiary proof by officially validating behavioral science in court. By executing these specific redlines, Parliament instantly bridges the gap between judicial precedent and statutory law, eliminating prosecutorial ambiguity without overhauling the entire legal code. Statutory recognition is a necessary legal prerequisite, but its efficacy depends entirely on the administrative infrastructure tasked with enforcing it. To manage complex welfare cases, the AVS requires a specialized prosecution unit dedicated exclusively to sentience and psychological harm. Prosecuting psychological suffering means measuring the invisible. Enforcement must rely strictly on empirical science. This requires behavioral expert protocols. Integrating veterinary ethology allows investigators to translate signs of fear and distress into rigorous legal evidence. Furthermore, a multi-stakeholder advisory committee is necessary to continuously update these standards as our understanding of animal cognition advances. Upgrading the law must be paired with upgrading the scientific literacy of the enforcement apparatus. Without this infrastructure, the amended law remains symbolic. We are approaching a strict timeline. The Ministry of National Development's public consultation, targeted for late 2026, represents the primary window for institutional reform. This reform reflects Singapore's broader societal evolution. It aligns directly with the nation's city in nature vision, shifting our legal framework away from antiquated property paradigms. There is also a distinct geopolitical advantage. Passing this blueprint establishes immediate regional leadership for Singapore regarding animal welfare standards within the ASEAN community. Driving compassionate innovation in our legal frameworks is a tangible, measurable extension of international soft power and governance excellence. The core argument is clear. The science of sentience is settled. The judiciary acts upon it. Legislature must now close the loop. This 2026 review provides a rigorous test of Singapore's commitment to evidence-based law, ensuring its statutes match the modern standards of a leading global jurisdiction.